Imagine walking out to the pristine, private lake tucked behind your family's generational homestead, only to find a swarm of entitled suburban residents paddleboarding across your water, claiming that your personal shoreline, your docks, and your fish belong to their HOA. Hit that subscribe button right now, because this is the ultimate story of corporate entitlement meeting cold, hard property law, and watching an arrogant legal team implode in front of a judge has never been this satisfying. When I stepped out onto my wooden deck that morning, coffee mug in hand, and saw a half-dozen strangers treating my family's private water body like a public municipal resort, my blood went instantly cold. Leading the invasion was a smug real estate attorney wearing a $1,000 suit, holding a laminated map, and shouting orders like he owned the hemisphere. All residents of Whispering Pines are officially notified that this water body is designated as common interest community property. The lawyer announced, his voice booming across the calm surface of the lake. He was actually attempting to steal a privately deeded, spring-fed lake that my grandfather had legally carved into our ranch over 80 years ago. Welcome to the absolute peak of HOA insanity, where power-tripping boards and corporate lawyers believe they can rewrite land deeds just because their expensive subdivision views look better with a sparkling blue lake in the background. To understand how a quiet property owner ended up in a courtroom showdown where opposing counsel threw down his files and walked out mid-hearing, you have to go back to when Whispering Pines was first built. For decades, our borders were defined by rolling hills, dense timber, and absolute peace. But then a massive development firm bought out the old pasture next door, threw up 90 cookie-cutter luxury homes, and marketed them with one major selling point: lakeside luxury living. There was just one fatal flaw in their master marketing pitch. The lake wasn't theirs. It sat entirely within the boundaries of my family's private land grant, fed by an underground spring that we maintained at our own expense. When the new homeowners moved in, they immediately assumed every scenic feature within walking distance was part of their monthly dues. At first, it was just stray paddleboards floating near our private boat dock. Then came the plastic lounge chairs dragged across our lawn. And finally, when we politely asked them to get off our property, the HOA board decided to skip polite conversation entirely. They hired a high-priced corporate law firm, filed a formal declaratory judgment, and dragged us into civil court, convinced that a judge would simply hand over our private water rights to satisfy a wealthy neighborhood's amenity list. Most people would have panicked facing a battery of corporate lawyers with bottomless financial backing. I didn't. I didn't even hire an expensive defense attorney. I just let them march straight into their own legal trap. Because what that fancy corporate lawyer didn't know, what he couldn't possibly have factored into his carefully rehearsed arguments, was that sitting right inside my leather briefcase, waiting for the exact right moment to be unsealed, was a territorial land patent signed by the state governor in 1900 for that explicitly declared the lake bed, the water rights, and the surrounding shoreline as an indivisible part of our private homestead. And the hearing was about to begin in 10 minutes. The heavy oak doors of the county municipal courtroom creaked open, admitting a blast of cold air conditioning that did nothing to lower the sweltering tension inside the room. I walked in carrying a single worn leather briefcase, wearing my usual canvas field jacket and jeans. Across the aisle, sitting at the plaintiff's table like corporate royalty, was Richard Sterling, a senior partner at a high-flying real estate firm. Flanked by 3 junior associates weighed down by massive rolling carts stacked high with glossy color-coded exhibits, binders, and zoning manifests. Sterling didn't even look up as I took a seat at the opposing table. He was too busy whispering instructions to his team, exuding the casual, untouchable arrogance of a man who billable-hored his way through life and viewed small landowners as mere speed bumps on the road to a summary judgment. A sharp rap of a wooden gavel echoed through the chamber. "All rise for the Honorable Judge Thomas," the bailiff barked. Judge Thomas swept into the room, his black robes rustling, and took his seat behind the elevated mahogany bench. He cast a tired, experienced gaze over the courtroom before adjusting his glasses and pulling our case file toward him. State versus Whispering Pines Homeowners Association versus Estate of Miller. Judge Thomas read aloud, his voice dry. "Counsel, You have requested a preliminary declaratory judgment regarding water access and common property designation on Parcel 4B. Mr. Sterling, you may begin your opening statement for the association. Sterling rose smoothly from his chair, buttoning his $1,000 suit jacket with theatrical precision. He flashed a confident, gleaming smile toward the judge, as if he were presenting a winning closing argument to a massive corporate jury. Your Honor, Sterling began, his voice ringing out with rich, practiced resonance. The undisputed facts of this matter are simple, clear, and absolute. The Whispering Pines residential development was constructed under a municipal master plan that explicitly incorporates the adjacent aquatic feature, commonly known as Whispering Pines Lake, as a primary recreational amenity for its residents. He turned and pointed a dramatic finger straight across the room at me. For over 2 years, the defendant has belligerently barred tax-paying homeowners from accessing what municipal maps designate as a shared community water resource. The community's master covenants, filed under State Housing Code Section 4, establish a clear right of continuous public utility and recreational easement over that shoreline. We are simply asking this court to enforce the law, recognize the community's vested interest, and grant an immediate injunction halting the defendant's unlawful restriction of neighborhood access. Sterling dropped back into his leather chair, looking thoroughly pleased with himself. He didn't just think he had won. He looked like he was already calculating his billable hours for the victory dinner. Judge Thomas rubbed the bridge of his nose, letting out a slow, heavy sigh. He looked down at the mountain of legal binders piled high on Sterling's table, and then shifted his gaze slowly across the room to me. Mr. Miller, Judge Thomas said, quietly, his tone measured and weary. The plaintiff has presented a heavily documented brief regarding municipal development guidelines and subdivision zoning overlays. Do you have an opening statement or any documentation to counter their claim? I slowly stood up, resting both hands flat on the wooden table. The entire courtroom seemed to hold its breath. Sterling didn't even bother to turn around. He just smirked and began flipping casually through a color-coded binder. Your Honor, I said, my voice cutting cleanly through the quiet room. Mr. Sterling is entirely correct about one thing. The facts of this case are absolute. I reached down, popped the metal latches of my worn leather briefcase, and pulled out a single heavy, yellowed piece of parchment secured inside a protective plastic sleeve. The only problem, I continued, stepping out from behind the table, is that Mr. Sterling is reading from zoning maps printed last year. He hasn't looked at the actual foundation of this land. Sterling let out a sharp, dismissive scoff and leaned back in his chair, shaking his head. Your Honor, objection, Sterling interrupted, not even bothering to stand. The defense is holding some decorative historical relic. It has zero bearing on modern municipal zoning law or contemporary HOA master covenants. Judge Thomas held up a single hand, silencing Sterling instantly. The judge's eyes locked onto the yellowed document in my hand, and a strange, sharp intensity flashed across his face. Mr. Sterling, Judge Thomas said, his voice dropping into a dangerous, icy register. Before you dismiss opposing counsel's evidence, you might want to ask yourself what document he is actually holding. Because if that paper is what I think it is, your entire multi-million-dollar lawsuit just turned to dust. Sterling froze, his smirk faltering as a sudden bead of sweat broke out on his forehead. The courtroom fell into an absolute, suffocating silence. You could have heard a pin drop on the polished linoleum floor. Richard Sterling slowly pushed his chair back and stood up, smoothing his tie with fingers that had suddenly started to tremble just a fraction of an inch. His professional, untouchable confidence was rapidly evaporating, replaced by the creeping unease of a high-priced attorney realizing he had walked his client straight into a legal wood chipper. Your Honor, with all due respect, Sterling said, forcing a tight, uneasy smile back onto his face. Whatever decorative parchment the defendant has dug up from a flea market is completely irrelevant. Under modern state real estate statutes, historical land grants are superseded by contemporary municipal zoning laws and registered HOA master covenants. Case law on this is absolute. Judge Thomas didn't even blink. He leaned forward over the mahogany bench, resting his forearms on the wood, his eyes boring straight into Sterling. "Counsel," Judge Thomas said, his voice cold and steady, "are you telling this court that modern municipal zoning code can legally override a federal territorial land patent?" Sterling opened his mouth to reply, but the words caught in his throat. He blinked, swallowed hard, and looked down at his junior associates for backup. They were frantically flipping through glowing laptop screens and color-coded tabs, looking just as terrified as he was. "Well, no, Your Honor, of course not," Sterling stammered, his polished veneer cracking at the edges. "Federal patents hold constitutional weight, but nothing—" Judge Thomas interrupted sharply. He pointed a finger down at my worn leather briefcase. "Mr. Miller, approach the bench and present your evidence." I walked forward, keeping my stride calm and deliberate, and laid the heavy, yellowed parchment flat on the judge's desk. It wasn't a modern zoning printout or a standard county deed. It was an original state-certified territorial land patent, signed and sealed in 1904 by the sitting territorial governor, granting absolute, unencumbered ownership of the land, including the spring-fed lake bed, all surrounding shoreline, and exclusive subterranean water rights, to my great-grandfather in perpetuity. Judge Thomas adjusted his glasses, leaned down close to the parchment, and ran his fingers gently along the faded red wax seal and the embossed state stamp. For nearly a full minute, the only sound in the courtroom was the low, mechanical hum of the overhead air conditioner. Finally, Judge Thomas sat back up. A slow, almost amused smile touched the corners of his mouth. He looked across the courtroom at Sterling, who was now sweating visibly beneath the bright fluorescent lights. "Mr. Sterling," Judge Thomas said smoothly, "have you ever actually read the foundational property lineage of the Whispering Pines development?" Sterling swallowed hard, his voice dropping an octave. "Your Honor, the developers assured our firm that all historical encumbrances were wiped clean during the 2018 commercial rezoning." "Then your developers lied to you?" Judge Thomas replied coldly. He picked up a wooden gavel, though he didn't strike it, because this 1904 patent explicitly establishes this Pacific Lake as an indivisible, private water body tied permanently to the Miller homestead. It is completely exempt from municipal annexation, HOA easements, or public utility common interest codes. The courtroom erupted into a chaotic whisper. Behind Sterling, two members of the Whispering Pines HOA board, who had been sitting in the gallery wearing smug, expensive suits, suddenly went completely pale. Sterling grabbed the edge of his table, his knuckles turning white. "Your Honor, this is an outrage. If our residents can't access the lake, property values in the entire subdivision will plummet by millions. The association has already invested heavily in community docks and paddleboard storage." Judge Thomas's expression hardened instantly into stone. "That," the judge said, his voice ringing out with absolute finality, "is a civil matter between your association and the real estate developers who sold you a fraudulent dream." He looked straight at Sterling's legal team and then delivered the blow that completely shattered their entire case. "Furthermore, since your association has spent the last 2 years actively trespassing on private property, operating unpermitted watercraft, and harassing the legal landowners, I am prepared to not only dismiss your declaratory judgment with prejudice, but to grant the defense an immediate countermotion for corporate trespassing and property damages." Sterling stood frozen like a statue. The multi-million-dollar lawsuit he had promised his clients was dead in the water. And then, things took an even crazier turn. The sudden weight of the judge's ruling hit the plaintiff's table like a physical blow. Richard Sterling stood completely paralyzed, his mouth slightly open, staring down at the mahogany table as if he couldn't comprehend the words that had just been spoken. For a high-powered senior partner who had never lost a real estate liability case in his career, this wasn't just a loss, it was an absolute professional humiliation. Behind him in the gallery, the Whispering Pines HOA board members began muttering frantically among themselves. One of them, a wealthy tech executive wearing a designer tie, leaned forward and hissed something directly into Sterling's ear. Sterling didn't turn around. He didn't even acknowledge the man. His face had gone completely pale under the harsh courtroom lights, the confident facade completely stripped away, leaving only raw panic. Judge Thomas looked down from a bench, raising an eyebrow. "Well, Mr. Sterling, do you have any closing arguments to offer before I enter the final dismissal and schedule the damages hearing?" Sterling slowly turned his head to look up at the judge. He opened his mouth to speak, but no sound came out. He swallowed hard, his eyes darting frantically between the judge, the yellowed 1904 patent on the bench, and his own team of junior associates who were desperately sliding sticky notes across the table. Instead of arguing, Sterling let out a short, hollow laugh. He reached down, grabbed his expensive Montblanc pen off the desk, and dropped it heavily onto his legal pad. Then, with slow, deliberate movements, he began gathering his files, stuffing glossy binders and contract folios back into his leather briefcase with zero regard for organization. "Counsel?" Judge Thomas asked, his voice sharpening with a warning edge. "I asked if you have a response." Sterling zipped his briefcase shut with a harsh, metallic zip that echoed sharply across the quiet room. He stood up straight, buttoned his suit jacket, and looked the judge dead in the eye. "Your Honor," Sterling said, his voice flat, exhausted, and utterly devoid of its previous corporate swagger. "Effective immediately, the firm of Sterling and Vance formally withdraws as legal counsel of record for the Whispering Pines Homeowners Association." The entire courtroom gasped. Behind Sterling, the HOA board members shot out of their gallery seats as if they had been hit with a cattle prod. "What?" the tech executive shouted, violating half a dozen courtroom protocols in his panic. "You can't just quit mid-hearing. We paid your firm a six-figure retainer." Judge Thomas slammed his wooden gavel down once with a sharp crack that rattled the microphones. "Silence in my courtroom," the judge bellowed, his voice filling the room. He glared down at the frantic board members before fixing his stern gaze back on Sterling. "Mr. Sterling, you cannot simply abandon your clients on the record because your case fell apart. You are tied to this proceeding until final judgment." Sterling didn't even flinch. He reached into his breast pocket, pulled out a crisp, folded white envelope, and laid it neatly on the corner of the plaintiff's table. "My formal notice of withdrawal, accompanied by a motion for immediate contract termination due to client misrepresentation of foundational property facts, has just been filed with the clerk's office," Sterling said coldly. He turned his back on the judge, picked up his leather briefcase, and walked straight down the center aisle of the courtroom without once looking at his flabbergasted clients. The heavy oak doors swung open, letting in a brief flash of hallway light, and then slammed shut behind him. The high-paid corporate lawyer had literally quit mid-hearing and abandoned his clients to wolves. The Whispering Pines board members were left standing in the gallery, staring at the empty seat where their defense had just evaporated. Judge Thomas looked down at the abandoned board members, a faint, sardonic smile playing across his lips. He picked up his pen and signed the dismissal order across the 1904 patent. "Well," Judge Thomas said smoothly, "it appears the plaintiffs are currently unrepresented. Mr. Miller, since your countermotion for corporate trespassing and property damages is still on the table, how would you like to proceed?" I looked back at the terrified HOA board, knowing that the real game was only just beginning. The silence in the courtroom was so absolute, you could hear the electronic hum of the digital court recorders spinning down. The Whispering Pines board members stood frozen in the gallery, looking like lost tourists who had accidentally wandered into a maximum security prison. Their high-priced legal shield had just abandoned them in a cardboard box, their multi-million-dollar lawsuit was officially dead, and the judge was staring right at them with an expression that screamed zero tolerance. "Well?" Judge Thomas asked, his voice echoing smoothly across the room. "Do the remaining representatives of the Homeowner Association wish to retain new counsel, or are you prepared to address the defense's countermotion for property damages right now?" The tech executive, who had been shouting just moments earlier, slumped heavily back into his wooden bench seat, burying his face in his hands. Beside him, an older board member stood up on shaky legs, buttoning his suit jacket with trembling fingers. "Your Honor," the board member squeaked, his voice cracking with pure panic. We We would like to request a recess to consult with our remaining board members." Judge Thomas glanced down at his watch, then back at the terrified men. "Request denied," the judge replied flatly. "You chose to bring this frivolous, bad-faith litigation into my court, and you chose to ignore the clear property titles long before you ever filed a brief. You can consult with each other right there at the plaintiff's table." He picked up his wooden gavel. "Mr. Miller, the floor is yours for your countermotion." I stood up, picked up a single folder containing 2 years' worth of photographic evidence, security logs, and certified repair bills, and walked to the podium. I didn't need a fancy law degree or a team of associates. The math was simple. For 24 months, the residents of Whispering Pines had treated my family's private lake like their personal municipal playground. They had cut our perimeter fences to install unauthorized boat docks. They had littered beer cans and plastic paddleboard debris across our shoreline. They had even hired commercial landscapers to dump organic yard waste directly into our spring-fed water body, severely threatening the local ecosystem. "Your Honor," I began, my voice clear and steady. Over the past 24 months, the defendant has logged over 412 documented instances of illegal trespassing, property defacement, and ecological dumping by Whispering Pines residents acting under the direct authorization of their HOA board. I laid out the photographic evidence across the podium, letting the clear, high-resolution images speak for themselves. We are seeking immediate financial restitution for industrial property restoration, security gate installations, and environmental cleanup costs, totaling $450,000. Furthermore, we are petitioning the court for a permanent, legally binding injunction. Any homeowner caught stepping foot within 50 yards of the Miller Homestead shoreline will face immediate arrest for criminal trespassing. The board members gasped in unison. $450,000 was enough to completely wipe out the HOA's entire reserve fund and force a catastrophic special assessment on every single household in the subdivision. "Your Honor, please," the older board member pleaded, practically sobbing from the plaintiff's table. "That amount will bankrupt our entire community. People's retirement savings are tied up in those homes." Judge Thomas looked down at the pleading men, his expression cold and unforgiving. "Should have thought about that before you tried to steal private property," the judge said. He brought his gavel down with a sharp, resounding crack. "Motion granted in full. The Plaintiff Association is ordered to pay $450,000 in damages to the Miller estate, effective immediately. Furthermore, the permanent injunction restricting all public access to the private lake is hereby entered into court record." By the following weekend, the fallout inside Whispering Pines was nothing short of an apocalyptic disaster. Word spread through the neighborhood that their board had not only lost the lawsuit, but had saddled every single household with a massive 5-figure special assessment to pay off our damages settlement. Property values in the subdivision instantly plummeted as angry homeowners realized they couldn't even sell their houses, with a pending HOA bankruptcy hanging over their heads. The entire board was forced to resign in total disgrace within 48 hours, hounded out of the neighborhood by furious residents who finally realized what happens when you let corporate greed override basic property law. As for me, I used the settlement funds to build a state-of-the-art security gate, clear out the debris, and restore our family lake to absolute, uninterrupted peace. Whenever I sit out on my wooden deck with my morning coffee, watching the glassy, undisturbed surface of the water, I can't help but smile. Some people pay $1 million for lakeside luxury living. In my case, an arrogant HOA paid me $500,000 just to admire it from behind a locked fence.